The market capitalization of the coin is used to summarize all that is taught in this video. Additionally, I would ask that you support my channel by liking it and subscribing to it so that you can stay up to date on future XRP news, as well as other cryptocurrency news in general. Have a look at this for a moment. Is Judge attempting to reach a confidential agreement with Ripple? On the other hand, before we go any further, there is a brand new cryptocurrency airdrop that is currently taking place on Telegram and is set to start at any moment. I would ask that you make sure that you take part in this airdrop. Within the video's description is where you will find the link. Make sure you don't miss out on this opportunity. In the meantime, let's proceed with our video. Ripple's disagreement with the Securities and Exchange Commission (SEC) has taken an unexpected turn, which is generating new interest from individuals all throughout the cryptocurrency industry. In the United States, a federal judge is urging Ripple and the Securities and Exchange Commission (QO) to consider the option of settling significant portions of their complaint rather than going through the lengthy judicial procedure. This is in contrast to the alternative, which is to go through the lengthy judicial method. At a time when Ripple is getting ready to file a big appeal with the Second Circuit Court of Appeals in January of 2025, this recommendation comes at a time when the company is getting ready to do so. These are the recommendations that Judge Phyllis Hamilton made. Ripple has been asked by a judge to consider alternative possible settlements to the pending disagreement. In a recent court filing, Judge Hamilton recommended both Ripple and the SEC to consider alternative potential remedies rather of going through the entire legal process for specific charges. This recommendation was made without regard to the individual allegations themselves. This action was taken in order to prevent the prospect of more legal action being taken. After the conclusion of the appeal, the court made a suggestion that they take into account the possibility of voluntarily dropping some claims without prejudice against them. Taking this into consideration would suggest that certain statements might be re-examined. Together with its CEO Brad Garlinghouse and XRP, Ripple is attempting to achieve a definitive judgment in order to prevent more claims from being filed against the company. Both of the parties have been provided with the opportunity to either take this course of action or continue with the procedure that is now being carried out. It has been requested by the court that they provide a response to this proposition by the 4th of November. In the meantime, the Securities and Exchange Commission has reopened proceedings against Chris Larson and Garlinghouse, the CEOs of Ripple, arguing that the sale of XRP is in violation of regulations that govern securities. Ripple has increased the size of its legal team in order to get ready for a fight against the Securities and Exchange Commission (SEC), which intends to submit its major appeal arguments through the 15th of January in the year 2025. The ultimate decision from the court is what Ripple is hoping to achieve. In response to charges that Ripple violated securities laws, the primary plaintiff, Bradley Sostak, who is representing XRR investors together with Ripple and CEO Brad Garlinghouse, has demanded that the court make a ruling that sets the record straight. In addition to this, they asked that any further claims that were being filed at the state level be put on hold until the primary class action was adjudicated. The plaintiffs are considering filing an appeal against the earlier ruling-related XRP trades that spanned 6 years. This is because a recent attempt to reach a settlement was unsuccessful, and as a result, the plaintiffs are considering appealing the verdict. The most recent step in the Ripple Labs investigation is a lawsuit about XRP. Litigation, the defendant CEO Brad Garlinghouse, Ripple Labs, and XRP have submitted a request to the court requesting that a final judgment be declared on the plaintiff class action claims, and that a stay be imposed on individual state law claims until the matter is completed. An order has been issued by the court demanding that the parties take into consideration the potential of a different conclusion to the dispute. Ripple and the plaintiffs in the XRP lawsuit have been asked by the judge to reassess their position with regard to the joint petition that the parties have submitted in order to obtain a definitive decision and temporarily suspend the proceedings in the XRP litigation. In the most recent court filing in the Ripple lapsing dispute, Judge Phyllis Hamilton affirmed the position that the parties had taken. Nevertheless, the judge issued an order that they must take into account an alternative settlement, which is to submit a voluntary dismissal without negatively affecting the individual claim that is still outstanding. This was the order that the judge gave. It is important to note that the claim may be resubmitted after the completion of the appeal of the class claims of securities law violation that were made by Ripple, Brad Garlinghouse, and XRP LLC. This is a fact that is quite relevant. In its conclusion, the court ruled that if the parties are willing to consider this alternative, then the court will make its decision. A request has been made to the court for them to submit an amended proposed order. A motion was submitted to the court by the lead plaintiff, Bradley Sostak, along with Ripple Labs, XRP, and Brad Garlinghouse, requesting that the court issue a final judgment on the class action claims that the plaintiffs have regarding violations of securities legislation. In the event that the parties are not amenable, the court requests that they file a notice to that effect by November 4, 2024. Additionally, the court requests that they file a joint motion to file a class action lawsuit regarding Ripple XRP, an injunction from the state prohibiting any future activities that are connected to allegations of violations of state securities legislation until the classification of class action claims has been resolved. The settlement conference that was held to resolve the XRP litigation did not result in a good outcome for the various parties involved. It is the goal of the individual plaintiffs to file an appeal against the summary judgment order that was granted by this court in order to resolve the class claims. When compared to the class claims, which entail all XRP purchases done over a period of 6 years, the class claims are more comprehensive. The individual claim pertains to financial transactions that were carried out by a single consumer in the month of January in 2018. On December 19th, a meeting to discuss the pre-trial proceedings is scheduled to take place, and on January 21st, the jury selection process and the trial itself are scheduled to take place. Judge Hamilton has just issued orders on 4 motions that were submitted in the Ripple action. These orders were given in accordance with the Daubert rule, which is currently being considered upon by the court. The bulk of the court's ruling was made in favor of the plaintiff's request, which was granted. Therefore, the plaintiffs were successful in their case. At the same time, an appeal will be filed about the Ripple South Carolina case. As a result of the submission of Form C by both parties, the litigation that Ripple and the SEC have been pursuing is going to be taken to the United States Second Circuit Court of Appeal. Ripple executives Brad Garlinghouse and Chris Larson have been charged with violating securities law, which is a remarkable action on the part of the government. The charges were brought against them. During this time, representatives from Ripple Labs, including Brad Garlinghouse and Chris Larson, sought out notable attorneys in the appeals court in order to disprove the assertions that were being made in the XRP complaint. A motion has been presented to the Court of the Second Circuit by the Securities and Exchange Commission of the United States, seeking that the deadline for the filing of its major brief regarding the appeals be set for January 15, 2025. Despite the fact that market circumstances are generally hopeful, the price of XRP has maintained quite close to the 52 cents level throughout the course of this week. A decrease of 17 cents over the course of this month has resulted in the current price, which is 52 cents only. It is particularly notable that the futures markets are experiencing the most substantial buying activity as open interest continues to climb. This is a phenomenon that is particularly noteworthy. Within the context of this particular claim, the XRP transaction that was carried out by a single buyer in January of 2018 is the primary emphasis. The trial is scheduled to start on January 21st, while the trash roll conferences are scheduled to take place on December 19th. On January 21st, the procedure of selecting an appropriate jury will take place. Links is a Ripple CC appeal, and the post-it note for the post titles is slated to be released in the year 2025. Ripple and the Securities and Exchange Commission CC have been brought before the Second Circuit Court of Appeals, which will hear their case in January of 2025. Ripple executives Brad Garlinghouse and Chris Larson were accused of breaking securities laws, according to claims that were recently resurrected by the Securities and Exchange Commission from the shadows. There is a possibility that this appeal will have a substantial impact on the final result of the case. There is ongoing legal upheaval. In spite of the fact that it has dropped by 17% over the course of this month, the price of XRPS has remained unchanged at 52 cents. It is not a particularly surprised turn of events that the Securities and Exchange Commission, which is a regulatory institution in the United States, has been focusing its attention on a number of Bitcoin companies. It should be noted that the material that has been supplied is not intended to serve as business advice. In the event that any investments are made on the basis of the information that is provided on this page, there is no responsibility for those investments. Prior to making any choice on investments, we strongly recommend performing independent research and talking with a professional who is educated in the field.